This time I'd like to call the meeting of Tennessee Auctioneer Commission to order. And I would like to yield my position to Mr. Morris.
Okay, I'm going to act in Howard's stead today. If you would, call the roll.
Bobby Colson,
Here.
Ronnie Collier,
Here.
Adam Lewis,
Here.
Jeff Morris,
Here.
Howard Phillips is absent. You have a quorum, Chairman.
Thank you. Would you read the notice of meeting, please?
Yes. This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission's website since October 22nd, 2014. This meeting was also noticed on tn.gov's website.
All right, do we adopt that?
No, sir.
Okay, if you would,
Just a
go ahead
notice.
and let's look at the agenda for today. You've got it in front of you, gentlemen, and we need to adopt the agenda for today's meeting.
As a note, this agenda is amended.
As amended, excuse me.
I make a motion to accept it.
Been made.
Second.
Second. All in favor say aye.
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 All right, we have our agenda adopted. You have the minutes. You have been sent the minutes in an email. I hope you've read those. You also have them in front of you. We need to review and adopt those.
We adopt the minutes from the October 6, 2014 meeting.
It's been moved.
I'll second.
It's been seconded by Ronnie Collier. All in favor say aye.
Aye.
Ayes, moved and adopted. National Auction School is probably not here.
Yes, they were not able to attend today, but they did provide me with a short update. They're continuing to negotiate with the venue in Memphis, and forgive me, Mr. Morris,
Do what now?
the venue in Memphis,
What's-
Esplanade.
Esplanade.
Esplanade. Okay,
Esplanade.
my apologies. For a February seminar.
Awesome.
Um,
Finally.
Yes, and the tentative date is set for the 23rd. Again, that is still tentative. And then they're also looking to have the other seminar at the Nelson Andrews Leadership Lodge on May 5th here in Nashville. And they're also compiling the information for the December newsline, and they would like to feature some information about Mr. Lewis, our newest commission member. So we'll be reaching out to you, Mr. Lewis, either I or Ressa or possibly both. So that is all from Nashville Auction School.
All right. Chris, you want to read us through the first item in our legal report? Like I said, we'll stop the meeting as soon as the judge gets here, and we'll adjourn this meeting, and then we'll start the formal hearing that was on the schedule prior to this meeting.
You know, I don't know, I'd kind of hate to start the legal report and then have to stop it.
Okay? You want to go through the administrative
You can't go
part?
anywhere till we're done anyway, so why don't we go to the administrative report?
That would be fine.
Because I think that'll be the easier stuff to get.
Absolutely. Absolutely. Why don't we do that,
We can
Kimberly?
certainly do that.
We'll juggle this around a little bit.
Okay. Tab 3, this is actually representative information. Since today is the first working day of the month, we actually haven't prepared the newest performance measure. So last month is still at 93.75%. I'll give everybody time to get to tab 4.
Theodore Flashnet.
Yes, sir. And if you can flip over.
Sure.
8. This application was submitted, it is a reciprocal application, and the gentleman applying referenced several complaints and some time that his license was, in essence, suspended. And I wanted to present this to the commission. This is sort of out of the ordinary.
Go back to the part about it's a reciprocal.
State of Wisconsin.
Yes, sir.
We do reciprocate with Wisconsin.
How many complaints has he had?
It appeared to be 3 complaints, and then there was a discrepancy on his original application. There's a 96 complaint, a 97 complaint, 98 complaint, and then there was this whole piece where they were talking about there was the discrepancy on his original license, that everything was okay, and then all of a sudden a complaint was opened against him.
It's a good place for us to stop, because we're gonna have to get
Yes.
into this one a little bit.
Yeah, so much for my idea, going to the easy stuff.
And that's the truth. We now have our judge with us.
Sorry, I'm late, gentlemen, ladies.
At this point, we'll adjourn the regular meeting of the Tennessee Auctioneers Commission, and we will start here in just a minute with our formal hearing.
Sorry, would you make sure you talk into the mic? They're weirdly sensitive. Thank you.
Okay. Today's date is November the 3rd, 2014. This is a hearing before the Department of Commerce and Insurance, before the Tennessee Auctioneers versus in the matter of the Great South Auction Group, docket number 12.15-12664. Agent, the administrative judge assigned by the Secretary of State to hear this case. Board hearing, so there are some instructions I need to give to the board members. You all are the triers of fact in this matter. I have I in no way make also be given the opportunity to ask questions of the witnesses. You're to base your decisions just on the evidence that you hear today, documents and or testimony that might be presented to you today. Can I get the board members to identify themselves for the record, please?
Yes, I'll start. I'm Jeff Morris.
Bobby Colson.
Ronnie Collier.
Adam Lewis.
All right, we have a quorum. All right, very good. And the respondent is present, is that correct? Is there a representative for Great South Auction Group? And who is? All right, Mr. Jones, is this organization a corporation?
No.
It is not, okay. Would you mind coming forward, please, and having a seat, I guess, at that table? Is there a microphone over there for Mr. Jones? Okay. Do we have any questions up to this point as to how we're going to proceed? Further than, boy, this microphone is strange. You can just, if you're not at it, it doesn't work. Okay. Have an opening statement from the state, please.
I have not yet passed.
You've got a problem because you don't have a mic up there either.
But I've got a big mouth, so I okay. Am I right?
Well, except
Well-
it doesn't get recorded.
Well, I'm not going to say it.
We're not recording.
We're not recording. Okay. Well, then we don't have to worry about it then.
I won't say a big mouth. I'll say adequate. How's that? How's that?
Thank you.
All right.
Your Honor, I have not passed out a notice of hearing and charges. May I pass that out?
Yes, you may, please.
I will tell the commission that there are 2 documents and an original only changed the date because we originally had it set for last month. I'd like to see that as well and have that, but it is exactly the same thing with just
Please, if you don't mind. Everybody had a chance to review the documents? We're ready to proceed, Ms. Ryan.
Go ahead, Ms. Ryan.
Thank you. The issues today concern John Addison, who will be appearing today via affidavit with Win purchase was an engine. The proof will show was listed with a serial number, website, listed as used, and then it was to fit an RS13 Superliner Mac with a year of 1989. Pictures provided on that website showed an identification plate, engine model 500 with the serial number mentioned with the year 1989. Picked up after the auction, there were two different plates that indicated the engine was not. One plate had E95 model number, but another had information concerning E944HB. Showed that the number stamped on the engine block is E944HB with a serial number 2R7016, which makes it not a State would assert that these are very serious and substantial differences. After the auction was completed, and that as such they are serious violations of the rules of this commission concerning advertisements, which are in place to protect fraudulent advertising. Those laws are in 6219-112B1. Asking today that at the conclusion of the proof and after hearing every
All right, is it Mr. Jones, is that correct?
Yes, Your Honor.
Okay. Ms. Ryan, if you have no objection, because Mr. Jones is not represented and probably is not familiar with the term opening statement, what I may do is testify at this time, and then, of course, you'll be able.
before I put on any other proof, Your Honor?
If you prefer, we'll do it. If you'd prefer to go ahead and put on your first.
I would.
Okay. All right. Well, in that case, Mr. Jones, you got some idea of what an opening statement sounds like. You'll have an opportunity to give as much detail as you like at some point, but if you'd like to right now, you can give me just a general explanation of what your position is in this matter.
Like I said, I'm Chris Jones, I'm part owner in Great South Auction, and on behalf of my part owner and auction, I'd like to thank you guys for being here and taking time out of your schedule.
I think right now you've done a good job of presenting just what your position is, and we'll get to your proof at a later point. All right, Ms. Ryan, if you'd like to call your first witness or begin to present your case, please.
Call Kimberly Whaley.
Whaley, if you'd raise your right hand and be sworn, please. Do you swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth? All right, go ahead,
I do.
Ms. Ryan.
Would you please state your full name for the record?
Kimberly Whaley Morgan.
And Ms. Whaley,
I still am, yes.
Thank you. Would you please state your position with the state of Tennessee?
I am the Director of Licensing for the Division of Regulatory Boards.
And as the Director of Licensing, are you familiar with this particular commission that is the Tennessee?
I am.
Are you then therefore familiar with this particular complaint and the license?
I am.
Have you reviewed the license and the complaint files of Great South Auction Group?
I have.
When did Great South first get the license?
Our records indicate that the first license for Great South Auctions was issued on March 20th, 2009.
And what kind of license was that?
A auctioneer firm.
And what is the address for the record for this license?
5930 Highway 128 South, Savannah, Tennessee 38372.
And when was this?
This complaint was opened on 3/19/2014.
And what was the reason for this complaint?
The complainant stated that the item they purchased did not match what was advertised. That's a very summed up version.
Okay.
The complainant stated that the engine was advertised as a E9 500 horsepower engine with a number of 9E1659. When the item was picked up, there were actually two plates on the engine. One was an E9 500 and an E9 440 with a number of 2R7016. And this was the second number indicated that the item was a 1982 instead of the advertised 1989.
Did he also provide copies and documentation of the?
Yes, ma'am, he did.
And did it include pictures of the engine?
Yes, ma'am. First page is the bill of sale, and the subsequent pages are various pieces of the advertising, including pictures of various parts of the engine.
And this is all the same lot number?
Yes, ma'am. The lot on the bill of sale is 3194. The lot on the subsequent pages, 3194, 3194, 3194. 3194, 3194, finally 3194.
In the lot on the advertisement itself, was there anything else besides that particular engine listed?
This is the only item.
And can you tell me what it says about the?
Yes, the serial number is listed on the right under Equipment Specifications, Mack Engine, Mack, Location Tennessee, serial number 9E1659. I believe this page is a little blurry. Yes, 1659. The general information provided says, engine has had new heads and injection pump, does not crank and run. Engine will push water out when under load. We think the liner may be cracked. Fits to RW713 Superliner Mack year 1989.
And does it say whether it's a used or rebuilt model?
The condition under equipment specifications states used.
Okay. If the clerk please, may I pass it? On the bill of sale on the first page, what does it say about the item that was actually sold?
It says actual 1982 E9 440 2R7016 on block.
Is that the same or different from what was advertised?
That is different.
In what way was it?
Can I object to that, Your Honor?
You can object to the question. Do you have a basis? Yes.
Do have a basis.
What is the basis?
The basis is that's not my bill of sale. I have.
Ms. Ryan, you'd like to respond to that?
Your Honor, that is the bill of sale that was provided to us from the complainant and is attached to the complaint, as attached to the affidavit, and it testified to as the affidavit and as of.
Yes, Your Honor.
You say this is not your bill of sale. Explain that to me, please.
Because of the handwriting on it, sir. I have a copy of my original bill of sale. Yes, Your Honor.
Don't you have any idea where this alleged false bill of sale would have come from?
Yes, Your Honor.
And what is your thought on that matter?
It's generated by the original purchaser of the engine. I have proof I can further.
Where would he have gotten a
Admit that.
copy of your documents?
We always give a document of bill of sale when they pay for it, sir.
Blank document that he could have
No, sir.
subsequently
If you'll
filled out?
notice that we waive the wire fee and the wire transfer fee, we draw lines through it when they present us with a cashier's check instead of a wire transfer.
Well, my question is, if this document is not your bill of sale, where would he have gotten a copy?
He had the original. He
a
has
blank
exactly
copy?
what he has exactly what you have in your hand, and evidently he's took this back, which I will prove later on how he wrote this serial number on this bill of sale, sir.
Right. Your objection will be noted. And Ms. Ryan, what is your position here?
Our position is that that is the bill of sale that came. I haven't seen what he has at all, so I can't tell you what the differences are.
Okay. All right. Well, I'll reserve my ruling then on your objection, Mr. Jones, but it is noted in the record.
Was this a live auction?
No, it was an online auction.
And you have copies of the online auction information, is that correct? That's
Advertisement.
what we already looked at earlier about being a Mack engine.
Yes, ma'am.
Okay. What did Mr. Adderson say in his complaint concerning the engine?
The engine was,
You could just read what he said if you would in his complaint.
yes, that's the complaint basis. The engine was intentionally identifies as a Mack E9 500 horsepower engine, S/N 9E1659. When we picked it up, there was actually two different identification plates on two different valve covers. Engine actually has 4 valve covers. The E9-500 plate that the seller used to advertise it. The other plate was for a E9 440 HP. The identification number that is actually stamped on the engine block is E9 440 HP S/N 2R7016. This serial number corresponds with a 1982 build, not a 1989 that was advertised. All this information can be verified with Mack Dealer.
Was this copy of this sent out to the respondent to get any reply from them?
Yes, it was.
Did you ever hear anything that could have cleared this up if this was not?
So the complaint, initial complaint was signed for, but no response was received by our office.
Ever?
No, ma'am.
And I'm going to ask if you can identify this document for me.
Yes, the first page is a new matter transmittal, transmitting this to our legal counsel. The second page, second, third, fourth page are actually the online complaint that was submitted by the complainant. The next page is the letter that was sent to Great South Auction on March 19th related to the complaint. The next page is a letter that was sent to the respondent alerting them that we had submitted, we had sent the complaint out for response. And then the final page is a listing of their licenses.
Is this?
Yes.
May I pass it out, Your Honor?
Yes, has Mr. Jones seen a copy of it? Okay.
If the court please, I'd like to make this the first exhibit.
Any objection, Mr. Jones?
Oh, Your Honor.
All right, we'll have it so marked and entered.
And I'd like to make the copy of the online advertising as exhibit number 2.
Objection, Mr. Jones?
No, sir. No, Your Honor.
All right, we'll have it then so marked and entered.
Thank you. What is the complaint process?
The complaint process is once the complaint is received, it is reviewed by the administrative manager or the director. It is then sent out for response, opened, while also being opened in our complaint system. The respondent has 30 days with which to respond to the complaint. After 30 days, or at the time a response is received, the matter is then additionally reviewed and forwarded to our legal counsel. Legal counsel will then review it and present it to the commission.
Is that presented anonymously or with the name of the respondent?
No, ma'am, it is presented anonymously to the commission at their next scheduled meeting. The commission then hears the facts and makes a determination, and will then decide if a civil penalty is necessary. Once that has been decided, following the meeting, a consent order will be issued if one has been authorized by the commission. And then the respondent then has 30 days with which to comply or pay for the consent order. If they choose not to, the matter goes forward and formal charges are authorized in it.
So, what laws govern advertising for auctioneers?
62-19-112.
And particularly, is that B, subsection B?
Yes.
And what numbers?
B 1 and 7.
What does B1 say, please?
Making any substantial misrepresentation. And 7 is violating any provision of this chapter, rule, or regulation duly promulgated under this chapter.
Are there rules concerning advertising?
Yes, there are.
What are the rules concerning advertising?
Advertising rules are found in 160-01-.20, specifically subsection 2A through D.
Could you read that, please?
Yes. False, deceptive, misleading, and untruthful advertising is expressly prohibited. Any advertisement or advertising shall be deemed to be false, deceptive, misleading, or untruthful if it A, contains a misrepresentation of fact, B, is misleading or deceptive because in its contents or in the context in which it is presented, it makes only a partial disclosure of relevant facts, C, creates a false or unjustified expectation of services to be performed, D, contains any representation or claim that the advertising licensee in bad faith fails to perform.
Now, does it say anything in that rule?
No.
Is there anything in the commission's rules that differentiate between
Auctioneer is responsible.
So the auctioneer has to follow the rules, make sure that they're not misleading, no matter what the... When does this current license expire?
Currently, Great South Auction expires 3/19/2015.
And who is listed as the owner of Great Auction?
Jeremiah Melson.
Mr. Jones is not listed anywhere as a co-owner?
I do not our system.
Well, is that something the commission should know? Is that something they're required to report when they change ownership, or there's a change of ownership?
Are
And there's been no notification that there's another or a co-owner. Are there any other current complaints outstanding against Great Auction?
there are not?
Okay. Have there been complaints filed in the past?
Yes.
Have they been resolved?
Yes.
I do, Your Honor.
Before you start, let me ask you a question. What is your position with this?
I'm part owner, sir.
You're part owner.
Yes, sir.
Are you listed there as such?
Evidently not here on the board, no, sir.
I would object, Your Honor, for him representing the company in any way. He is the auctioneer involved, so I intend to call him as a witness, but as he is not listed as an owner, he
I'm not an auctioneer, ma'am.
Do you have any proof that you're a part owner?
I have an escrow account, sir, that I have to sign a two-party check on, sir. Well, the company does, sir. Has to have two signatures on it. That's the way the bank set it up, sir.
But you're not listed as an owner of this company.
No, sir. I was affiliate. Excuse me, sir. I was an apprentice auctioneer, which those licenses have expired. And basically, my part at the company now, I just organize the equipment for sales, and et cetera, et cetera.
I renew my objection, Your Honor.
They have a business card. I mean,
Tell the court, it is my understanding that the listed owner may be present.
Listed owner of Great South Auctions present? You're here? All right. Okay, I'll deny your motion. I'm thinking, or my initial thinking was there might be an issue of standing here, but as long as the listed owner is present, and Jones is his designee, I guess, in terms of representing him at this point. All this, and you're not a corporation? You're solely owned? Okay. Then I'll deny your motion, and we'll continue. Now, go ahead, Mr. Jones. You have any questions for Ms. Whaley?
I do, sir. Once again, Ms. Whaley, thank you for being here.
Information that was in the original complaint that he stated. And again, I'm reading the complaint basis directly from it, quoting it. The E9 500 plate that the seller used to advertise it, the other plate was an E9 440 HP. The identification number was actually stamped. The identification number that is actually stamped on the engine block is E9 440 HP S/N 2R7016. And he stated there were two different identification plates on the different valve covers. Engine was actually has four valve covers. The serial number corresponds with a 1982 build, not a 1989 that was advertised. All this information can be verified with a Mac dealer.
Ryan?
It's the same thing, you're just in black and white, a little bit easier to read.
For persons to view.
All right, we have a discrepancy here as to what was actually on the website versus what was not on the website. I'm going to allow you to let Ms. Whaley see the color photograph of apparently what she already has. The other, I'm not going to allow you to pass that out because apparently, according to the state anyway, it was not on the website. You're saying it was on the web.
No, Your Honor. This document has the web address.
That document does. The other documents, I think Ms. Ryan is calling into question. Ms. Ryan, did you make a discovery request?
I did not. I've not heard from Mr. Jones at all. The first page of the documents he has there is, can I finish what
Just a
I'm
moment, let her finish. And
The first page of the documents I have is exactly a copy of what has been passed out. I have no objection to the first page.
All right.
My objection to the other pages are there's a blown-up photo covering the information, which is not exactly as it is listed on the website, and that's my objection to that.
No, ma'am.
Covers up the information, Your Honor. It covers up the information that they have already, and that's my objection. All the information is covered up by this blown.
well, I'm going to allow him to pass him out to Ms. Whaley, and we'll see what his questions have to be. And of course, you'll have the opportunity to redirect.
I'm not disputing her one-page documents. Exactly.
All right, go ahead and let Ms. Whaley take a look at those, and we'll let. Do you have copies for the board members?
No, Your Honor, I don't have no.
Okay. All right. Well, that's all right. Now you may ask Ms. Whaley questions based on those photographs. Of course, you understand Ms. Ryan's going to have the opportunity to ask questions as well, and the board will have opportunity to ask questions.
Okay. To make the commission aware, this is exactly if you're.
You're testifying right now. We'll get to that in just a minute. Whether, yeah. All right, Ms. Whaley, have you had an opportunity to look at those photographs? All right, Mr. Jones, do you have any questions regarding those?
No, Your Honor. Yes, Your Honor, I do. I'm sorry.
Okay.
Looking here, sorry. Miss Whaley, on my first page. Just go by engine specifications. What was listed there?
Engine specifications or equipment specifications?
And I can't hardly.
Fits to Mac engine, manufacturer Mac, location Tennessee, serial number 9E1659, condition used.
Okay. And can you under general?
Engine has had new heads and injection pump does crank and run. Engine will push out water when under load. We think the liner has been cracked. Fits to RW713 Superliner Mac year 189,
What was that year model again?
1989.
And, for the record, that was.
Signed.
Okay. And can you continue to read if you.
Terms and conditions.
Yes, ma'am.
Questions, call us today, 731-926-4200. 2486 or 731-607-5782. Successful bidders must contact us within 24 hours of the completion of the auction to verify method of payment. No equipment will be released until payment is made in full. All equipment is advertised to the best of our knowledge, and everything is sold as is with no guarantees. All sales are final. Call with questions regarding the auction before making a bid. Items must be removed within 2 weeks of the conclusion of the auction unless other arrangements have been made. Payment must be received and paid in full within 72 hours of completion of the auction. Payment method is wire transfer or certified check, required within 3 business days.
And apologize, no. All right, and
I'll sustain the objection unless you have something pertinent to enter into.
well, give me those other pages. Do you have any problem?
I can see the pages that are presented in front of me. I don't know what I'm being asked.
Something pertinent about those pages, Mr. Jones?
Yes, we do.
Is there information on those pages that's not contained on the initial page that you've discussed?
That's what I'm asking.
Well, is that your point in introducing them?
That is correct, Your Honor.
All right. And how is she to know that? And you need to ask some questions that might.
On the last page, I believe in that, go.
I'm going to sustain the objection. Mr. Jones, I know you're not an attorney, but there are some very strict regulations or rules, procedural rules, when it comes to introducing photographic evidence or photographs into evidence. And those rules generally are that you have to be the person who took the photograph. You took that photograph, and it's online.
Yes, I did. I told you my position is I organize and take
Picture of it, of that particular document already on the documents provided to the commission. I cannot tell, we can't have verification that it's one and the same, and it's not just a blow up of something else at all. I can say that the documents provided to the commission reflect the same small pictures on what he has provided the commission today.
I'm going to overrule your objection and let him pursue this for the moment. So,
And I'm also going to object, Your Honor, I have to tell you, and I know he's a pro se litigant, but there was no witness and exhibit list provided to me at all, no opportunity to review or investigate any of this at all until today, and I'm going to object to that. He had plenty of time to file a witness and exhibit list as well.
I'll sustain it on that basis. No, you cannot use those documents. Not provide a witness and exhibit list to the state as spelled out in the order that was provided to your company.
thought that's what I was bringing.
Well, you brought it, but you know, and I know you're not an attorney, but that's one of the problems you run into when you don't have an attorney, is that, you know, you're under an obligation based on the pre-hearing order to provide a list of your witnesses and a list of your exhibits to the state's attorney. I believe it's 7 days prior to the hearing, and you have failed to do that, which means that you cannot introduce any exhibits or technically produce any witnesses to testify that aren't on a witness and exhibit list, and there is no witness and exhibit list. So I'm not going to allow you to enter those, to use those documents since they weren't provided prior to the hearing.
Let's go back to the document provided.
Seller information, Great South Auction Group, Savannah, Tennessee. Phone number 731-607-5782. Fax number 731-926-2487. Send Great South Auction Group a message.
But who
I do
owns-
not see a license number or a Tennessee firm license number listed on this
And
advertising.
Also in the top left-hand corner,
Auctiontime.com is listed at the very top of the page. At the bottom of the page, it lists www.auctiontime.com, online auctions, details, and optional computer link. I can read what's at the bottom. I'm
Right,
not,
okay, okay.
I did not produce the document, and I'm
okay. And then
not an
the
expert.
documents that I'm trying to submit, can you read at the bottom of that page for us, please?
I'm gonna object,
On the first page. the
I'm gonna
first
object,
page
Your Honor.
That you allow.
I think she just read.
The one submitted to the court, Your Honor.
Well, the other documents are inadmissible. There's no information on those documents that would be admissible. Redirect.
Just a couple. On all the documents and all the pictures you show, who is listed as the auction company?
Seller information is Great South Auction Group.
And the information listed is then therefore items apparently offered for sale by Great South.
Yes, seller information is Great South.
And does anywhere in that page it says that this seller offers this information, but, or we didn't offer this information? Advertisement, the only person involved with the advertisement would be Great South?
Auction time is listed at the top.
And would that be true no matter what document you're looking at, that's the information provided? Great South Auction is providing the information for this lot number for this auction?
Yes.
Thank you.
I read.
Else, Mr. Jones?
Yeah, I'd like to redirect.
Yes, go ahead.
Objection, Your Honor, that's been asked and answered.
All right, Mr. Jones, that question has already been asked and answered. Do you have a different
Can she
question?
read what's
What's out beside it, Ms. Whaley?
No buyer fees, no hidden reserves. That's directly to the right of auctiontime.com.
which is the heading on top of the paper, correct?
Objection again, Your Honor. This is a document that is not before. Oh, I'm sorry, this is on the advertisement we had. I apologize. I withdraw it.
Go ahead.
Can you read the subtitle?
Construction, farm equipment, trucks, trailers, attachments, other items.
And, can you continue to read?
Auction dates, attachments, auction results, live auction board.
Okay. And,
All right, anything further from either attorney for Ms. Whaley? All right, do any of the board members have questions for Ms. Whaley?
Who is the principal auctioneer of Great South Auction?
Yes, sir. The principal auctioneer is listed as Jeremiah Melson.
Thank you.
Further questions from the board? Is that all for
I
Ms.
have one question.
Okay.
Does it state in, in their application or in their license what type of company it is? Whether it be a sole proprietorship, or the LLC, or corporation?
I don't have their application in front of me. It's not recorded in the system.
Anything further? All right, thank you, Ms. Whaley. You may step down.
Your Honor, if the court please, I'm going to actually have her read the affidavit of the next witness that is appearing by affidavit.
Ms. Whaley to do that?
Please, thank you.
Any objection, Mr. Jones?
No, Your Honor.
All right.
Next witness I call is John Addison, who is appearing today via affidavit. There are no objections.
Yes, go ahead.
Affidavit, State of Tennessee, County of Roane. I, John Addison, having been duly sworn and based on personal knowledge, say as follows. My name is John Addison, and I work for Winrock Truck Parts and Equipment, Inc., located in Oliver Springs, Tennessee. On or about February 12th, 2014, I purchased for the company Winrock Lot 3194 Mack engine, lot number 3194, in an online auction from Great South Auction Group. According to Great South Auction Group's online advertisement regarding lot 3194, the item serial number was listed as 9E1659. The condition was listed as used, and the general information section included the statement, Fitz RW713 Superliner Mack year 1989. A copy of the online advertisement is attached to my affidavit. Great South Auction Group's online advertisement for Lot 3194 included approximately 7 photographs of the item. One such photograph features an identification plate including engine model E9500, serial number 9E1659, the model year 1989. When my father, Bill Addison, picked up the engine, he saw there were 2 different identification plates indicating that the motor was used. One plate featured the information of E9500 plate, which was utilized in Great South Auction Group's advertisement, and another plate featured information for an E9440 HP. The identification number that is stamped on the engine block is E9440 HP, serial number 2R7016, which corresponds to the 1982 model and not the 1989 model that was advertised. Attached to this affidavit is a copy of the bill of sale from Great South Auction Group.
Your Honor, I will tell the court that the actual bill of sale that is in question I attached to the other exhibit.
Do I have the right to ask you?
No, you do not.
Oh,
David, testimony, you were presented with the intention of the state to present affidavit testimony, at which time you have the right to request to cross-examine the affiant. Again, you're a pro se person. You know, with an attorney, they would have known that you could have done that at that time, but now you cannot.
okay.
Testimony, the affidavit comes in as unrebutted sworn testimony.
Okay, Your Honor. Is the motion to have witness appear via telephone, is that what we're talking about right now?
No, we're talking
No, okay,
about an
okay,
affidavit.
No problem.
I'm assuming we'll get to,
Your Honor, I filed a motion to appear via telephone in case there was an objection filed to the affidavit.
Okay, I didn't receive that piece of mail till yesterday, this via the telephone, and it notes in this that it was sent regular mail instead of certified mail. I mean, that was,
Have any idea when it was mailed, Ms. Ryan?
I don't, if he's talking about the telephone, I don't know. I can tell you that the affidavit was mailed to him on the 22nd of.
All right, and apparently from what Ms. Ryan was telling me, the issue regarding telephone testimony is not relevant because that was the affiant that she intended to have testify by telephone. If there was any objection to the affidavit, any appropriate objection to the affidavit, and
well,
there,
I'd just like the court to note what was read.
well,
Okay,
I'm sorry, I don't
that's fine.
understand what you mean.
That, I have no objection to that. I'm just.
Okay,
just
well, I
taking
just wanted you to
consideration
understand
what
that
was read.
the affidavit comes in as
Sure.
unrebutted sworn testimony.
Mhm.
Okay? All right, anything further, Ms. Ryan?
Respondent, Your Honor? Actually, through Mr. Jones?
Are you calling Mr. Jones?
I am.
All right. Raise your hand and be sworn. Mr. Jones, do you swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth?
Do, Your Honor.
All right, go ahead.
Could I ask him to take the witness?
Yes, could you take the witness stand, please?
Personally list this item for auction, Mr. Jones?
Yes, ma'am.
And you listed it as a 1989 with the serial number 90,
Yes, ma'am.
but that wasn't the correct serial number, was it?
Yes, ma'am.
Yes, ma'am, what?
It was the correct serial number listed on the valve cover.
So what was the other serial number that's also listed on the valve cover that shows that the model was actually a 1980?
That was not listed on the valve cover. It was listed on a block discovered by your plaintiff, I guess.
Well, why didn't you discover that before you put a listing on it on the website for advertisement?
Not an engine guru. I just took what was listed.
And you don't think it's significant that what was listed was a 1980?
The motor came out of a 1989 Mack truck. And that's why we said 1989. The title said 1989. The engine serial number that we used said 1989.
But there was another serial number on it, sir, wasn't there?
Discovered by your plaintiff.
Why didn't you discover it? If it was on the engine, you had control of the engine, you took the picture of the engine, why did you not discover that there was a second serial number and a second date before?
I have no idea where to look at. It was in black and white, a serial tag. That's what I took a picture of. And when it comes out of an 89 model Mack that I've personally seen it come out of, when that serial number matched that, ma'am, that is exactly what I put on there.
But there was another serial number on the exact same engine, wasn't there, sir?
According to your plaintiff.
Are you saying there wasn't?
I didn't see it.
Are you the only person that takes pictures?
I am.
And you don't think it's important to make sure?
It's very important.
So, why didn't you investigate the entire engine before you put it on?
I took the time to take 7 photos noted by your plaintiff all the way around the engine. The engine, he says, was stamped on the block. When I take it out of an 89 model truck, the engine serial number says date manufactured 89. I have no other questions.
But you did provide pictures, sir.
I did. And if you would want to see it in the court, I'm not denying the fact that we placed that serial number engine. I've got it right here. And the court's already noted that we had 8 or 7 photos of that. And if you'd went a little further on the investigation through the results, you would have seen that.
And when he purchased it, though, he raised the issue that it was not a 1989, didn't he?
We need to have him via the telephone to cross-examine him.
I'm asking you.
Yes, he did.
So, before and after he raised the issue with you, and what did you tell him?
I told him to leave the engine there and I would reimburse him.
Isn't it true what you really said was it doesn't matter and it's...
I did not say that.
Okay, did you tell anybody that this was a privilege?
They have in general conversation, I mean, not directly.
And he did complain, didn't he, that it was
He-
not the engine listed?
He did, and he took the engine back. Now, court, note this. He took the engine back to his place, called me about 2 to 3 weeks later, and wanted just partial payment back for the engine, and noted that he would call other auction people that we do business with and complain on me. I mean,
Did you give
I offered him opportunity to unload the engine the day he bought it and give his money back. He took it all the way back and then requested more money back. To me, it's, that's what happened. Any other questions?
Sir, it's true, though. Your identification of it, and you.
According to your plaintiff.
And you failed to provide that on the advertisement.
According to your plaintiff.
And you never saw it yourself?
I never saw it myself.
So you're saying that somehow he's not telling the truth, is that,
I never said that.
well then,
I mean, hey, look.
All right, we're getting a little argumentative here.
I
Let's-
offered to reimburse
Just a minute,
the
Mr.
man.
Jones, let me
Okay,
speak,
okay,
please.
I'm sorry, Your Honor.
We're getting argumentative. I don't want that. Ask the questions, answer the questions.
Yes, Your Honor.
You let her finish asking the questions, you let him finish answering the questions. And please not repeating the same questions over and over and over again. I think we've established that there is there were 2 numbers that were being used. He's established that he's claiming that he only saw 1, so let's move on from that. I think the board understands that at this point.
requirements are for advertising for an auctioneer company?
Other than what we was taught in auction school, ma'am.
Excuse me, other than what?
We was taught in auction school
And what were you taught in auction school?
that we shouldn't misrepresent anything,
And-
basically.
And were you taught about the rules? About the rules of the auctioneer commission that has imposed for people doing advertising?
Yes, ma'am.
And you made a great deal earlier that this auction listing online was a
No,
then what?
I was just trying to, your documentation showed them as the seller, just showed us as an advertising agent.
Where does it show them as the seller and you as the advertiser? Where does it show that, sir?
When it references auction results, auction dates, that's clearly an auction company if you use the documentation
Sir,
provided by the court.
in the advertisement itself, it says Great South Auction Group is the seller.
It says call for information, it
It
does.
says it's the seller information.
But
sir.
you provided your information from their website,
Does it?
auctiontime.com. Auction time, that's auction, and they provide dates, results, what they've got on there. They're the ones hosting it. I don't pay I don't pay them to put it up. I mean, it's
Are you
listed as
saying-
public knowledge.
Are you saying that they did the auction and not you?
They host it every Wednesday, yes, ma'am.
So are you saying you're not the seller as you have advertised on here?
Are you asking me, am I a seller?
I'm asking.
I am a seller.
Does it not say on the documents, the seller information on the documents, Great South Auction Group? Does it not say that?
I am a seller.
Does it?
Answer the question and stop trying to be evasive. Does it say that or not? That's a simple yes or no.
What'd she say again?
Ask the question again.
Does it not say under seller information, Great South Auction Group, Savannah,
Yes.
Tennessee? It does. And does it not say the equipment specifications listed underneath it, fits to a Mac engine?
That is correct.
Doesn't it also say there was a bid and the bidding information?
Yes, it does. But who,
And does it not also say under the general information, it talks about the fact that the engine has been new heads and injection pumps? Provide that information?
I did, and through further study from your plaintiff, he noted that, been rebuilt by Mac.
But it was listed as used, wasn't it? Not rebuilt.
Can you
Does it not
continue
say
to continue to read? Yes.
It says used, it doesn't say rebuilt.
Yes.
It does say rebuilt? Does it say rebuilt?
It doesn't say rebuilt, no.
Is there a difference between used and rebuilt?
Depends on when it was rebuilt and used, I mean.
Do you not have a responsibility to inform the public?
They sure can. If you'll go on and read, can you complete your advertisement that you looked at?
Do you not have the responsibility?
I do, I'm sorry.
And it turns out that all that information was not provided.
No.
Was the fact that it was a rebuilt engine instead?
That's not provided.
Was the fact that it was 1982, 1990? Was the additional serial number that was on the
Nope.
I have nothing further.
Jones, how many engines do y'all sell during the course of a month?
Course of a month, probably 2 to 3, maybe. Hmm.
40 a year?
More than likely, yes, Your Honor.
Are you in the habit of getting serial numbers off of valve covers?
That's where this one was located.
No, I said, are you in the habit of doing that?
Yes, Your Honor. On this particular Mac.
You're a professional.
On Mac engines, yes, sir. That's where they're located.
And you will take what's on a valve cover rather than what's stamped on an engine block?
On a Mac engine, they're listed on the valve cover, Your Honor. Especially when they come off of the door tag from a 89 model truck.
As a professional, you're willing to do that,
Yes, Your
even
Honor.
though knowing that changing valve covers on an engine is as simple as 4 or 5 bolts.
Probably not as simple on a Mac engine.
Oh, I see. Okay. It's certainly not as simple as changing it on what's stamped on a block, is it?
No, Your Honor.
Okay. And changing an engine from an 82 to an 89 model is not that difficult either, is it? And not that unheard of either, is it?
On this particular engine, it would be.
Oh, I see. Okay.
Yes.
All right. Do the board members have any questions for Mr. Jones?
Go ahead, Bobby.
Who was actually the seller? Who owned the motor?
That would be American Forestry.
American Forestry. So y'all were the selling agent
Yes,
for
Your Honor.
them,
Excuse me, yes, sir.
or Great South was the selling agent
Yes, sir.
for them. American Forestry? Okay. And I think we understand, or the board does, I'm not sure about our.
Further questions?
Did you say that you offered to let him leave the motor lane and give his money back?
Yes, sure did.
What's your objection to not willing to reimburse him part of his money back now?
Because he's already took the engine. I mean,
But
this
you-
has been since February.
But
I mean,
you offered to give
immediately
him all of it back
when
at
he
one time.
called and said something was wrong, he came back to the yard. I said, I'll give you a check back. It's a cashier's check. Just hand it right back to him. Unload. No, I'll go ahead and take it. He took it back, then waited, I'd say it's 3 or 4 weeks, and called me back and made reference to some other auction companies that anyway, and he thought the motor was worth $2,000. So I'm sending $1,500 back. I said, you've already got my engine. I can't send any money back. I mean,
But you was willing to.
at that point when he discovered it. I mean, this is just an oversight. I mean, I'm not denying this is what I'm doing, but I'm saying I'm a fair businessman. Yes, I did offer to pay him immediately.
What, I don't sell motors every day. What constitutes a rebuilt motor?
Usually on a rebuilt motor, it's rods and mains, maybe a head. I mean, he run the 82 number and discovered that it had been rebuilt. And if you want to know the rest of the story, this man sold this engine to this man. I mean, sorry, I'm sorry. But I'm sorry.
Did you know the motor had been rebuilt?
Yes, the older gentleman, I mean, it was,
But all you said it was
but
used.
now keep in mind, it was rebuilt, and one of the liners must have not have seated right. I noted that. When under load, when it was in the truck, it would get hot, push water out. And I made that, I mean,
Your Honor, I don't know if I can do this or not, that's the reason I'm asking. Ronnie sells this type of stuff a whole lot more than I do. So for information purposes for me and whoever, could I ask him something?
No, it really wouldn't be appropriate. Not at this time, anyway. You may be able to
Maybe when we're doing the
later.
discussion.
Right,
Okay,
right,
okay.
yeah.
I have a couple of questions, Your Honor. When you were talking about earlier their bill of sale versus your bill of sale, what differences were made and by whom, and what were you trying to say about that?
you have the document. Here's my document. When he picked it up, somebody, evidently maybe his shop guy, noted the big serial number difference. I mean,
Well, I assume that the writing on the one that we got was written not by y'all, but by somebody after the fact, making notes on the invoice.
Yes, sir.
Okay, so that was not the invoice as you presented it to them.
No, Your Honor.
But that
No,
was,
sir.
that was their own personal notes that they submitted to
Yes.
as part of their complaint. How do you explain the differences, how they discovered it was a 1982 versus a 1989? Was it just something that you didn't see, or didn't catch?
This engine is a V8 engine. It's shaped like this. It's not inline.
Right.
So evidently, he says it's on the block, and there again, I didn't see it.
Right.
So evidently, he knew where to look for whatever reason. Now, if it's rebuilt 1989, everything but the block was probably 1989. As it come out of a 89 model truck.
It was an
But now,
82 block, but it was an 89 motor.
I would bet my life on that. I mean,
When you offered to give him his money back, what was his reaction to that?
no, he just go ahead and take it. It was, and the court noted, I think this was a father-son operation. It was either the father picked the motor up.
At the time that you offered to give them their money back, had they discovered the fact that there was two numbers on the block?
That is why he came back. He went about 3 miles down the road and turned around, come right back. He sure did.
So he knew
Exactly right.
whatever he was going to complain about, he discovered that fact, came back to you, and you offered to give him his money back right there on the spot.
Because the girl had a cashier's check. He paid with it and was just going to hand it right back.
Okay. And then why do you think they didn't take the money back and then file the complaint?
Permission voice my knowledge. A V8 Mac is like finding a needle in a haystack. Those heads are worth about $9,000 a piece. So you do the math.
Okay. Do you think that the complainant was damaged financially in this transaction in any way?
Certainly not. I mean, he called back wanting a partial payment. I mean,
And how did he justify the partial payment back?
thought that was all the motor was worth. Instead of an 89 model, he said an 82 model.
Did you remind him that you had offered to give him all of his money back?
I sure did.
Okay.
You think it was your fault you didn't see the plate on the engine itself?
I don't think it was my fault because my shop people took it out of that truck. I mean, when I got a title and I got a VIN number that,
Match up.
I mean, once again, it's a V8 motor. Had I known to look at a block, maybe I would have found, I mean,
All right, anything further from Mr. Jones? Okay, you can take your seat, Mr. Jones.
Thank you, sir. Can I get my information?
Sure. Any further proof?
No, Your Honor, that concludes the state's proof.
All right, Mr. Jones, it's your turn to shine. Okay.
I'm not ready.
Do you have any witnesses that you'd like to call? Okay, any further proof? Anything else you'd like to tell me at this point? Oh, yeah, you will. Yeah, you will. All right, anything in closing?
Yes, Your Honor.
Ms. Ryan?
The issue here is advertisement. I already know from his own testimony that this Mac engine is rare. That's what he thought he was bidding on. All auctioneers do, to, when they advertisement, to do it in an honest, straightforward way. That's not what was done. The ability right engine was there. He said earlier that he does at least. That is somebody who does this regularly and should know and should have known how to look for all the proper information before advertising. The seriousness is, this was not a 1989. That makes a big difference. It was rebuilt, not used. That makes a big difference. Because the buyer took it and then later tried to negotiate, the difference between the values shouldn't play on anything. Bottom line is, we have rules in place about what we offer to the public as professionals, auctioneers, and responsibilities. You can't be misleading, you can't misrepresent. And perhaps fraud at the worst. The bottom line is, he had a responsibility to advertise what exactly he had and to make corrections if it wasn't correct. And he did not do so. I'm asking that he understands in the future that you can't be careless or laissez-faire about what you're offering. You can't blame it on the company that he has hired under the auctioneers online. It's his advertisement that goes online. He's responsible. The company is responsible. That is who is offering it to the public, and the reason we have these rules is so the public is not misinformed. They have a responsibility to do it right, and I'm asking today that you find that he did it wrong and issue a civil penalty and all costs in this matter.
All right, Mr. Jones.
Once again, thank you for being here. Long story short, my closing argument is I provided the information, no doubt about it. Upstanding, doing the moral, respectable thing of all. When he took it upon himself to carry the motor off, and then called back the second. Exactly what I was providing, what I was selling, and I did.
All right, board members, you've heard the evidence from both parties. Let me ask this, how many of these cases have you all heard before? Well, not how many, do you have any experience in hearing these cases before?
This is about the second or third one that we've been involved in. Some of us is the first one.
First one I've had.
First one you've had too. All right, well, let me go through this, and you more experienced members know what I'm talking about. Right now, you have to deliberate on the evidence that's been presented today. You have to do that in the open, out loud, in front of everyone here. And as a result of your deliberation at the appropriate time, you have to do three things. First, you have to make a finding of facts. That means you have to decide if what you've heard today is true or not true. If these allegations are true or not true, based on the evidence that's been presented. After you make a finding of fact, if you find that there has been some violation of rule or statute, you have to apply that violation to the law. A finding of fact, then you have to have conclusions of law. And if you find that the law has been violated, then you have to determine what punishment might be appropriate because of that violation. If you find that there was no violation, then of course that would end it right there. Thirdly, you have to make a policy finding, and that is just a basis, a reason for the decision that you came up with. If you have any questions during this process, I'll try to answer them best I can. But do you have any questions at this point?
I do. I'm just curious, and maybe in some of the documentation we've been given, what was the original fine? There was nothing sent from the commission?
That's something that you should not be considering here today. I can tell, but he's talking about what was presented in the consent order, what he could have settled it for originally.
Oh, okay. I didn't know there was a consent order. All right. You have proposed findings of fact and
I do, Your Honor.
conclusions of law? Okay. This is generally very helpful. Have two options here. You can look at these proposed findings of fact. Now, this has been prepared by the state, obviously. Now, you can review this, and if you decide that it goes along with what you decide after your deliberations, you can adopt these proposed findings of fact as your findings of fact. Then, of course, there's underneath that the conclusions of law. Again, that's proposed conclusions of law, and that's going to depend on what you determine to be the findings of fact. And again, that can be adopted from this document if you so choose.
I ask one question. Are there any way we could find out if Wind Rock Truck Parks were offered their money back? Does it say it anywhere, or have you been told that?
I will tell you that I don't believe I have any such information in anything in my file.
Let me answer that for you. The only evidence that's been presented here today was that they were offered their money back. That testimony is unrebutted, and it was made under oath. So you give it whatever weight you think is appropriate under those circumstances. Yes, sir.
Mr. Lewis, was you asking the money find or findings?
Not the findings.
The money.
What's the term that's used when they're sent?
Go ahead.
And I understand.
I'll let the attorney for the
okay.
board.
Typically, when boards offer to settle a matter short of a formal hearing, they do so by a document called a consent order. In a consent order, the respondent, if they agree to do so, will admit to certain findings of fact, certain violations of law or rules, and certain disciplinary action. I think what Ms. Ryan was attempting to get at earlier is under the evidence rules most of the time and subject to, Your Honor, verification, but typically settlement offers are not proper subjects for proof at a trial of any kind, including this one, absent some very specific circumstances that probably don't exist here, because the thinking being that it could well prejudice the board's thinking, deliberation, decision-making against the respondent. Well, if they had an opportunity to settle it for this and now, they just rejected it, it's human nature that the board members could hold that against the respondent when they should not, because the respondent's job is not to prove himself innocent. It is the state's job to prove that violations have occurred. So I hope that answers your question.
Curious, anything else?
Anything further? All right.
Your Honor, in our
Yes.
finding of facts, do we have a discussion first and then come up with our own finding of
Yes,
facts?
you need to do that first, and you can do one of two things. You can come up, if your findings of fact differ from those as proposed, then of course you can adopt those. If you look at the proposed findings of fact, and they tend to go along with what you perceive to be the findings of fact, or you can just adopt these as your
If we can
findings
do
of
that
fact.
now.
I think you need to have some discussion.
Okay.
Some deliberation prior to doing something like
Let's do that. We'll start our deliberations, and I'll just kind of help monitor that. We'll start with Ronnie, if you would.
Could I ask Mr. Jones one more question?
Yes, go ahead.
If you were given a choice of us sitting here doing what we're gonna do, of giving him his $1,500 back and forgetting all this mess, would you do it today or not?
I think that he kind of answered it more. I mean, human nature is human nature.
Yeah,
I mean,
I'm just, you know, I see a lot of stuff like that, you know, and if you made a mistake, you know, I mean, I would, if he refused his money, well, then he's come back, and I think you talked a little bit there, you didn't see the plate, which the plate was on the engine. It's got a picture right here. If you was given a choice right now to let us do what we're gonna do,
that engine plate is the one I took. That is the
Okay.
that was advertised.
but they still know you got one off of valve cover. But if you're right now, I'm asking you if you was given a choice for us to go ahead and do what we're gonna do, or you'd be willing to give him $1,500 to straighten this up, what would you do?
I don't think I'm at liberty to ask that at this point or answer that. I mean,
I'm not. It's just for my satisfaction. I think-
You don't have to answer that if you,
Well,
if you
no,
don't want
I mean-
to. And I'm kind of
But-
bending a little here,
Let-
bit here to even
I'm
allow
honest.
that question
I'm
to be
honest.
asked and answered.
I don't. It don't matter because they're in the auctioneer business just like I am, or supposed to be. I signed a. What they tell you it was? The one that they brought up for $500 a year ago, year and a half ago, whatever it was. Now, this that they wanted is a little bit more money than that. If I don't come and represent myself and plead my case, it's just a never-ending snowball. I mean, and once again, I'm a businessman just like y'all. I'm losing more money right now by being here trying to plead this
I
case,
understand.
and I know that's where you're going with it. I did what I done, but if I just keep on, who says next week that I'm gonna?
I think if you'd signed a consent order, we wouldn't be here today.
That's right, and that's why I'm here. I mean, I may not, you know.
Let's stop for just a minute here,
think
just a second here. What,
Ron,
yeah,
I will tell this commission that there was no.
all right.
That's why we're here,
Oh,
correct?
Well, but I'm saying there's no previous complaint with the consent order either.
Oh, I can understand.
Okay, I think we understand that.
there was, it sounds like to me there hasn't been any communication at all till today.
That's my next question is why didn't you cooperate with Miss Whaley when you were asking?
That's
What
because
was your
I was coming here to plead my case. I mean, and she did note the fact that there was a prior consent order and I paid the fine. Not on this matter, something other.
You had those, and like I said, if I ask something I ain't supposed to, I'm sure you'll tell me. You had those color copies of your webpage that, or of Auction Times webpage or whatever it was, that I was just curious, do you, I mean, I do a lot of online advertising. I don't do online auctions, but I do a lot of online advertising, and I'm just really not in the habit of taking pictures of my sales or printing them. And I was just curious as to why you happen to have that one from February. Is it on with a past sales
it was
thing?
still on.
It's still on
It's on a
record.
past
Yeah,
That's
sales.
auction
it's still-
time. It's
still
on a
be up there.
database. Yes,
See,
sir.
mine don't stay on there that long.
Yeah, auction time, they stay up there forever.
Okay.
Is it inappropriate for me to ask another question?
Oh, no. Go ahead. I'm kind of lenient about this. We're just trying to get to a solution.
Was there an
here.
inspection period prior to the sale?
Yes, sir. It's our policy, the way that we put it on that platform, that we post it 3 weeks prior to the Wednesday it sells. So if we're going to sell an item this Wednesday, it'll be 3 Wednesdays because it goes out in a publication also, paperback.
Your Honor, I'm gonna have to object to that because that's a piece of information that brand new, not presented in the case and proof.
Your Honor, I can rearrange that with what you've been provided. If you'll continue reading.
Say yes or no.
Sir,
Just answer yes or no
on what?
to what he asked you.
Was there an inspection period? Just as
Yes.
or- okay.
I'm sorry. Yeah. Maybe together we'll get this.
All right.
This was a question I was wanting to ask Ronnie a while ago, so you can.
Y'all are in
Once again,
deliberation.
we're
so you can
deliberating,
talk
so
about
you can
whatever
go ahead.
want.
You can ask me
We
a
can do
question.
it now, of course, you fool with more of this than I do as far as
I
this
don't
type of
necessarily,
stuff, motors and stuff like that.
I don't do I do the machinery, farm machinery, livestock.
Eddie does the motors, no.
Eddie does
But,
the motors,
okay.
yeah.
Well, I was just, we keep talking about, I sell cars, quite a bit too, and so we get talking about the plate. But the actual thing is not the plate, it's what's stamped on that motor, from what I understand. I mean, like I said, I'm not. If I could understand, if you knew it come out of an '89 truck and that, but that actually stamped it in the block. I think I heard somebody say that earlier. I mean, this is just
Right.
this is our discussion here, for what that's worth.
Well, I think our task right now, other than discussion, is there any other just general discussion, guys, that y'all have any questions about? Our first task is to find the facts in this case. We have a proposed finding of facts that's in front of us. I don't think there's any testimony on both sides about several of these finding of facts. Item number one, that the respondent was, and at all times pertinent here too, licensed as an auction firm with the Tennessee Auctioneer Commission, having been issued firm license number 5497. I think that's a finding of fact that we can all agree to, and that has not been disputed by either party. Number two, that owner about February the 12th, 2014, Windrock Truck Parts and Equipment, Inc., purchased lot number 3194, Mack engine, lot 3194, in an online auction listed with the respondent as the seller. There's been, I think that's a finding of fact that nobody can dispute or has disputed in this case. Number three, according to the respondent's online advertisement regarding lot 3194, the item serial number was listed as 9E1659. The condition was listed as quote-unquote used, and the general information section included the statement, quote, fits to RW 713 Superliner Mack year 1989, end quote. Again, that's a finding of fact that I think we can all agree to, and that has not been disputed by either side. Number four, respondent's online advertisement for lot number 3194 included approximately 7 photographs of the item. One such photograph features an identification plate including engine model E9-500, serial number 9E1659, and model year 1989. I think that's a finding of fact that we can all agree to, and that has not been disputed by either side. Number five, when the engine was picked up after the conclusion of the auction, there were actually 2 different identification plates indicating not only that the motor was used, but that it was also that it was rebuilt. One plate featured the information of the E9-500 plate, which was utilized in the respondent's advertisement, and another plate featured information for an E9-440 HP. I'm not sure that that information was part of a plate or was stamped onto the block. I don't know. I know the plate was found. Was there actually another plate found? I don't know, but whether it was just stamped onto the block as being that identification number. Did y'all hear any testimony as to?
I think the evidence presented was that the E9
stamped on the block. It was not another plate. So I would change that as to being.
Well, if you look at 6, it says it was stamped on the engine block, so for all we know, it could have been on another plate and on the engine block.
Well, I don't know. Was there actually 2 plates found? I'm not.
No,
Or was it one? Was there 1 plate and 1 stamp?
On his affidavit?
I think we had any testimony.
I think
to
that
that
the
either
evidence
way.
presented were there were 2 sets of valve covers, and
Was there 2 different plates on 2 different valve covers?
right, and it was also stamped on the block as well.
According to the affidavit from Mr. Adderson, he did say that there were 2 different identification plates.
What is the facts? That's what I'm trying to figure out. Was there 2 plates, or was there 1 plate and 1 stamp?
Okay, according to his affidavit, there was both. There was a plate and a stamp.
Okay, let's look at that.
When I say 1 plate featured the information of the E9 500 plate, which was utilized in the Great South Auction Group advertisement, and the other plate featured information for E9 440 HP, and then come on down to 6, and it says the E9 440 HP was stamped in the engine block. So apparently there was 2. It was in 2 places.
The testimony says that there were 2 different identification plates. Were they both in similar locations? That would
On
be
the
my
valve
question.
cover and the other was on the block, is what I understand.
What it sounds like to me.
Yeah.
What I'm trying to figure out is how was 1 ignored and was just as obvious as the first plate?
I can answer that. If I would have seen it,
Objection, Your Honor,
I
objection.
mean, I would have put it.
Objection.
What I remember from the testimony, obviously there's two sides to this particular question. The affidavit stating that there are 2 numbers on this item. The gentleman claims he only saw 1. I never heard him say he saw another. So,
What I don't think I realized till just now, the E9 440 was in 2 places, block and on a plate. Or a valve cover, or.
That's something I overlooked during the question and
Yeah,
testimony.
I didn't.
It says it's on a valve. One was on the valve cover and one on the stamp.
then the affidavit, it just says 2 plates. And then 6 mentions that it's stamped on the engine block.
And item number 6 says the end of, let's skip over number 5, because I'm going to go back to that. But item number 6 here says the identification number actually stamped on the engine block is E9 440 HP, serial number 2R7016, which corresponds to a 1982 model and not the 1989 model that was advertised. The other finding of fact that's not listed that I would like to enter into it was that number 7 was that the complainant was offered his money back but refused the money back offer and subsequently filed this complaint. I think that's a finding of fact that we have that's not included in our finding of facts. Do you gentlemen have any other facts that you would like to find in this case? If not, I assume that would be our finding of facts that we would make as a motion.
Put that in the form of a motion
And
and take
I
a
would-
vote.
So I would need that, gentlemen, if somebody to make that in the form of a motion, as I have read them and amended.
Okay. So move that the finding of facts that Commissioner Morris just read is our finding of facts
As I amended,
as amended.
as amended with number 7. Okay. Is there a second to that?
I'll second.
It's been made and seconded. Is there any further discussion about that? If not, I'll call for the vote. All in favor, please say aye. Or is this a roll call vote?
Not necessary.
Not necessarily? Okay. All in favor, say aye. Any opposed? All right, that motion carries as the finding of facts in this case. Our second task is to apply the violation of the law, or the conclusions of law, I guess, that we should come to, as pertaining to the findings of fact. There has been presented in front of you a proposed conclusion of law, which you may read, and we may adopt or amend. It's quite lengthy. If you gentlemen would like for me to read it, I will do that. You want me to read it to you, or you want to read it yourself? Guess it needs to be read into the record, Your Honor.
Not necessarily, but
Not
if you'd like to, you certainly could.
All of this in here. Some of this doesn't pertain to what we're talking about. Make a proposal, conclusion of law. Why don't I do this? I'm going to make this in the form of a motion. As a proposed conclusion of law, starting with that number 1, the respondent's acts and conduct as described in the foregoing allegations of fact constitute a violation of the Tennessee Code 6219-112, which states, in part, the commission may suspend, revoke, refused to renew any license issued under this chapter where the license has been obtained by false or fraudulent representation for any of the following causes. Number 1, making any substantial misrepresentation. And then number 7 under that rule says violating any provision of this chapter or any rule or regulation duly promulgated under this chapter. The second part of that says respondent's act and conduct as described above constitute a violation of Tennessee. You'll have to excuse me, what's COMP stand for? Comprehensive Rules and Regulations, 0160-01-20, which states in part. Paragraph 2 talks about false, deceptive, misleading, or untruthful advertising expressly prohibited. Any advertisement or advertising shall be deemed to be false, deceptive, or misleading, or untruthful if it, A, contains a misrepresentation of fact, B, is misleading or deceptive because in its content or in the context in which it is presented, it makes only a partial disclosure of relevant facts, C, creates a false or unjustified expectation of the services to be performed, And D, contains any representation or claim that the advertising licensee in bad faith fails to perform. Now, there's some other language in here that I don't, paragraphs E, F, and G, that I don't think pertains to this case. We could make that as our proposed conclusion of law. And I would welcome a motion to that effect.
Made the motion, and I would second it.
Okay. Been moved in second. Is there any discussion or any additions or changes or conversation about that? As I understand it, Your Honor, we're trying to basically, after our finding of facts, come to our conclusion of law as presented in this case. Right. All in favor say aye.
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 Motion carries as our conclusion of law. Now would be the time to determine the punishment or fines or whatever action that this board would like to present to the judge as punishment for the findings of fact and the conclusion of law. Is that correct, Your Honor?
Your Honor, I could direct them and to you as well that the section for civil penalties, if you're going to consider civil penalties, is in your rule 160.01.11, and that lists the various civil penalties that can be assessed pursuant to the violations that you've found.
That's on page 3, and it's 62 what?
Not 62,
Oh.
the rules.
Oh, okay.
0160-01-.11. It's not in your documents there, it's part of the rules. And if you want, I can have your attorney,
We have a copy of it.
okay.
Page 3, it's at 160.01-11.
Yeah, the civil penalties.
You got it.
And this is a violation of 62-19-112. Okay. And we have a range of penalty from $0 to $1,000 in this case. I think this is the time, if you guys have any personal feelings or recommendations as to what should be done in the case, this now would be the time to have those conversations. And we do have to do it out in the open.
Is it appropriate to ask what the court costs are?
Yes, that's separate from the civil penalties, but it is included in the notice of hearing and violations. Court costs would include the cost for the court reporter today, the cost for the judge to sit here and do anything that the judge has needed to do on this matter. I can tell you that the minimum is $200, which is way more than we have spent today. I would imagine it will be under $1,000, but I can't promise that. I will get that from these two parties after the conclusion of the hearing today, and they go back and total it for me.
You say that 200 is more?
No, 200 is what is initially charged for the filing of it. That's before we get to a hearing, and once we get to the hearing, it increases.
Do you think the total
So
court
it's gonna
cost would be,
200 plus the judge and the court reporter.
Well, yes.
and you think it'd be under $1,000
I
total?
believe it will be. I can't promise that.
Oh, I understand that. But your estimate right now
Yes,
is,
and that's because we are here in less than a half a day.
Okay.
So that's my estimate.
all right. Bob, do you have any personal feelings about this? Experience in the auction industry? Bonnie?
We gotta decide. I mean, it could be an honest mistake.
I mean, I've made mistakes too. When I went back and caught that part about it being on the plate and on the block, that kind of bothered me a little bit.
Right.
And lack of communication bothers me a lot. Being ignored.
I kept asking the question, if you had the opportunity to give him part of his money. I mean, I think it's an honest mistake, and if I made an honest mistake and I could have partial payment back, I'd be willing to do it myself. That's why I kept asking what I did.
Andy, I know you're not in the auction industry, but you're a consumer, and that's why you're on this commission, is to look at it from a different eye. Is there anything that sticks out in your mind?
Well, I think this is going to be an expensive lesson learned when it may be. Again, that's why I was asking earlier what the consent order was. It shouldn't make a difference at this point. I guess it was just more out of curiosity. I'm with you. I think the lack of communication is concerning, whether that was intentional or there wasn't a clear understanding of the process. Either way, the responsibility is still there. And I think that based on the testimony, my gut feeling is that it was an honest mistake, but that doesn't remove the responsibility to the law. And so at that point, I think, we've made our findings of fact. We've applied the law. It's just a matter of deciding the next step. Sorry.
Personally, and professionally, whatever, I felt a whole lot better here from the principal auctioneer. I mean, bottom line, that's where it falls.
Right.
Is the licensee is where it falls, and for whatever reason, the licensee chose not to speak.
Right.
And that kind of bothered me a little bit too.
Well,
A little late now.
Yeah, this is a kind of a one-sided conversation. Thank you, gentlemen, for your comments. I agree. My personal feelings are that this was mishandled from the get-go, and there's been mistake after mistake after mistake made in this case. The obvious first mistake was made is not catching that second plate. I understand that honest mistake, but when there's when you ignore the complaint filed, there's no response made immediately to the commission based on that, even though you intended to be here today, and you still file that, you still should have filed a response stating what your position was and stayed with that all the way through. And if it was an honest mistake, say it was an honest mistake. The fact that the guy refused to take the money and return the engine, that's in your favor. He obviously felt like he still got a good deal, or he would have taken the money back and gave you your inventory back. So that's a mitigating circumstance in my opinion. But the fact that you didn't hire an attorney, you didn't follow the court procedures. This is a very serious thing. The Tennessee Auctioneer Commission is set up to be fair to both sides. It's to be fair to the auctioneers. There's 3 of us on the commission. There's actually 4 of us typically. The 4th one's not here. So we see your side of the story big time. We're involved in this day in and day out. But we also see haphazard and sometimes intentional misleading activities, and we have to take this very seriously. That's why these laws are in place. That's why this board is in place. That's why we take our time out of our lives, and I'm away from my business to be up here once a month to do this, because I am passionate about protecting not only the consumer, but making sure that the auction profession is exactly that. It's a profession. It's not a part-time business that's to be monkeyed around with and to be done in a slipshod way. So, I'm good. My vote is that we're going to come up with a punishment. You gentlemen need to pay attention to that and know that this is very serious. And I know that you take it very seriously now. You may not have taken it as seriously before as you will after today. With that, the chair would hear a fine plus court costs. The court costs are given. We have found that the party is guilty as we have found in facts and the conclusion of law. Now we need to apply that, and our chair will hear a motion as to the amount of fine that would be levied.
Advertising violation, is that what the crux of it is, or?
You have two violations that you have accepted. One is a substantial misrepresentation, the other was a violation of your rules concerning advertisement.
And so is it up to 1,000 for each violation? Is that how to interpret it?
Going back to the rules, the violations of the various statutory sections are listed, $0 to $1,000 per violation. And it doesn't really apply here, I don't think, but it could be, if the violation were ongoing, you could assess it for each day it continued to be ongoing, but that's just interesting side note. And then moving further down to sub 3, says, in determining the amount of any penalty to be assessed pursuant to this rule, Commission may consider such factors as the following: whether the amount imposed will be a substantial economic deterrent to the violator, the circumstances leading to the violation, the severity of the violation and the risk of harm to the public, the economic benefits gained by the violator as a result of noncompliance, and the interest of the public. So those are, kind of your initial guideposts, and then again, the 0 to 1,000 is per violation, as we mentioned earlier.
We have a violation of which paragraphs?
You have a violation, you've accepted a violation, paragraph number 1, which carries a penalty of 0 to 1,000, and paragraph number 7, which also carries a civil penalty of 0 to 1,000.
It's two separate paragraphs.
That's correct.
Okay. Is there a motion? Looking for?
This is it.
Paragraph B1 and B7.
That's what I was looking for. We've got C, right?
May I, Your Honor? Your rule is a part of number 7.
Right.
The rule is
Okay,
cited,
okay,
but it's
okay.
included in the
Right.
violation for
Okay.
number
So
Yeah,
you've
7.
this
got
is
1
this.
and 7, I
Yeah,
see
1
now.
and 7
Okay.
are the law.
The representation.
Number 2 is the
and-
violation of the rule.
Okay, all right.
Would you like for me to make a recommendation?
Yes. See if we're thinking the same thing. Or I'll do it, I don't care.
Go ahead.
All right. I move that we fine $1,000 for misrepresentation and $1,000 for advertising plus court costs,
So it'd be a total of about $3,000.
thereabouts.
Mm-hmm.
I think you'd limit it to $1,000 per violation plus court costs.
Right, exactly.
Yeah.
So is that a total of $1,000 or 1,000 per?
1,000 per
So
violation.
it'd be $2,000 plus court
Plus
costs.
court costs, right.
Right.
I would make that in the form of a motion.
It's been moved. Is there a second? If you find that to be something that you're not comfortable with, you can make your own motion. Fails for lack of second. That's true.
I'm really going to lean on you gentlemen
Okay.
in this particular case, so.
Ronnie, would you like to make a recommendation?
Well, again, I think it's an honest mistake. I think we should do 500 for each plus court cost.
Yes.
I'll put that into
All right, Ronnie moves at $500 per violation plus court costs. Is there a second to that?
Or go 750.
I'll split the difference.
750.
All right, go ahead.
Need a motion.
Make another motion, Ronnie.
I'll make a motion, 750 for each violation. $750 each violation plus court cost.
That's been a motion for $750 per violation plus court costs. Is there a second?
Second.
Second. All in favor, please say aye.
Aye.
Aye. Motion passes. So our punishment is $750 times two violations plus court costs to be assessed to the respondent. Now, our fourth task is to have a policy finding and a reasoning for determining what we're doing. And I would read that into the court if you would make that in the form of a motion. You know, I move that that our policy finding is that we are here to protect the public from any misleading practices, whether they were intentional or not, that we are overseers of the auction industry and are trying to raise the standard of professional levels in the industry by adhering to the laws as we have them in front of us. And that is our policy of this board, to protect the public at all costs and to find in favor of the public when they are being violated. If the auctioneers have mitigating circumstances, we're here to hear those, and we do hear those, and we heard yours today. So, but that is our policy, is that we want to protect the public. Your Honor, that's all we have at this time.
Do I need to second this policy finding, and let's vote on it second?
Seconded. Is there all in favor of that? Say aye.
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 That concludes the hearing. Thank you, gentlemen. I think you did an excellent job. Appreciate everyone's participation. And with that, we are adjourned. Thank you all.
Thank you. I will collect those documents.
And we will take a 10-minute break, and we'll come back and start our regular hearing. We ready?
Yes, sir.
Okay, when we left off, we're back in session. This is the Tennessee Auctioneer Commission on November the 3rd, 2014, and we're reconvening after the formal hearing. When we left off earlier, we'd been through the roll call and the notice of meeting, the agenda, the minutes, which all are adopted. We're actually on the administrative report. No, we were on the application review, tab 4, and we're on this case from a reciprocal agreement from a guy from Wisconsin who has had some complaints filed against him. Can you summarize what you know about this case?
Yes, I can. Actually, what it comes down to is there's a lot of documentation here and a lot of facts. Apparently, all of them were rolled into one investigative case that Wisconsin conducted against Badger Auctioneers and Theodore Filsner together. And there's a variety of things, and I've kind of summarized
Please.
what. So the first thing, he had on his original application, he did not disclose some previous arrests and convictions, and that was several items like 3 through 13 in the final order and decision. Then
Are you talking about, are these arrests and convictions on his application in Wisconsin or on the application in Tennessee?
in his Wisconsin application.
So when he made his first application to Wisconsin, he didn't disclose that?
Yes, sir.
Okay.
There are things such as they asked that DWIs be disclosed, and he failed to do so. He also had a disorderly conduct. His license appears operating after revocation, obstructing an officer, several things that he did not disclose, and they're all listed.
Okay.
You can find this. I'm actually looking, starting on page 22 of 28. The next section concerned,
Now, are you saying that they gave him an auction license once they discovered all this, or did they discover all this after they gave him his
was granted the license, and apparently it was discovered post-licensure, and actually almost 10 years later that this all was discovered.
10 years later?
He says that he noticed it on his renewal in, I believe 97, and his original licensure was in 94. And he told them there were some errors, and they were like, that's okay. And then it all came out as part of this whole report.
Does he still
It's-
have a license in Wisconsin, or did they revoke it?
It was suspended for a time based on these facts and some other information. There's 71 items in total in the final decision and order. So
71?
there were 71 items. It's very, very detailed.
I understand that, but, so, now they suspended his license, but now it is not suspended?
Yes, sir. And the suspension was in 2000 and into 2001. He was suspended. The order originally says it would be suspended for 36 months, but it was actually suspended for 60 days, and the firm, I believe, was for 30 days. So there was a very short suspension resulting.
Well, all of this is 12 or 13 years ago?
Actually, I'm sorry. The firm was for 60 days. His was for 90 days. But it's all interrelated between he and the firm Badger,
Right,
which
but
is his firm.
this dates back to 2001 is what you're telling me.
Yes, sir. It is older, but I did want to bring it before the commission. I did not feel comfortable making a decision based on just.
Has he had any other complaint, revocation, suspension since 2001, 2002?
Not that was presented.
Okay. So for the last 12 or 13 years, he's been clean and had a license in Wisconsin and been operating his business. And he's filed for reciprocal agreement in Tennessee, and that's when all this came up?
Yes, sir. He provided all of this. He disclosed all of this in his application.
He disclosed it.
He disclosed it. He included, there were some notes from him which summarized in sorts what was in the investigation and then in the final order. And he does maintain that he did not, I want to make sure I quote him on this. The stipulation was entered into without any admission by Badger. And in fact, it continues to dispute the allegations, but he has served, and his license was restored based on, there was a order granting full licensure, and it laid out the things that he had to do, and his license was restored in April of 2004.
Now, his application is as a firm or as an individual or both?
Both. He's applying for a firm. He himself will be the principal auctioneer. Additionally, his wife, I believe it's his wife, is applying for auctioneer.
This is for a non-resident license?
Sir. It's my understanding they conduct auctions all over the country.
I got you. Based out of Wisconsin?
Mm-hmm.
He presently resides in Wisconsin.
Yes, sir.
And what age fellow is he?
I believe his birth date was 1960.
1960? No, so he's 54 years old. And it's up before us to either approve or disapprove his application? Is that what you're asking?
Yes, sir. Everything else, he paid the money. Everything else
Okay.
appears to be proper. I just did not feel comfortable given
Right.
the
I
vast
understand.
amount of
I
information.
understand. We have the right to approve it or disapprove it or whatever. Is there any questions from any of the board members? Anybody like to make a motion?
Barely. I mean, he put all this stuff in here, what happened, and it was like 10 or 12 years ago.
Yes, sir. everything stems from the audit report. Investigation report was dated 2000. He complied between 2000 and 2001 with the suspension of the company as well as his individual license. And
He's not getting an auctioneer's license, his wife is, right?
he is too.
Oh,
He's
he
going to
is.
be the principal for his firm.
I can only hear motions. I can't make motions, so. Do we have any cases like this that we've had in front of us before now that you're aware of?
Not that I'm aware of. That is, again, why I'm bringing this before you, is because I didn't have any, I don't believe in the last year since I've been
Right,
serving.
right. And I'm sure something like this has come before us before, but I'm not sure. Council, we don't have any reason why not to approve this, do we? Other than,
Well, actually, Mr. Chairman, I think it's a little beyond that. Most of the regulatory type regimes are basically, you meet the requirements, it is shall issue unless, and, you know, if you fail to meet one of the things, then that's the unless, and you can deny, suspend, revoke, refuse to renew on that basis. If there's something like that doesn't exist and this person or company or whoever does meet the license requirements, I think the board is obligated to grant them a license. And as I read the information submitted by Mr. Fleisner, it appears that the incidents that he was involved in criminally were all misdemeanors
Right.
and not felonies. And it also does not appear that they were crimes of moral turpitude, basically meaning dishonesty or money stealing or things
Right.
like that. So I think if it's Ms. Whaley's position that Mr. Fleisner and his firm have otherwise met the requirements for licensure, unless this board has other ideas and evidence to support them that are based on statute or rule, then I think then they probably qualify for a license.
I move we
do-
approve
I-
the application.
Okay. I do want to bring forward one item simply because we didn't go through the full 71 items. There were problems with their trust account, with their accounting records, and those types of things. I just want full disclosure of what's
and when
actually-
was that?
Again, those all stem back prior to 2001 and prior.
Can you tell by all of the filings what was the problem and why were the charges filed? I mean, what happened without having to read all the 71 pages and coming up with our own story?
Yes, basically, it appears that several of them were generated from complaints filed by people and minor disputes with his clients. And it apparently led to the department auditing him and going and kind of doing a little deeper dig.
Under this same company name?
Yes, sir. Yes, sir.
Was he the principal auctioneer back then, or can you tell?
I'm assuming so, based on everything mentions Badger, his name and Badger.
Right.
There was one where he got into a yelling match with a client that resulted in a misdemeanor. Then, let's see, problems with auction records, financial records revealed Badger failed to reconcile its trial balance.
Again, all of this goes back 12 or 13 years ago, and there's been no complaints since then that we know of.
That we know of. I can certainly get more information from
Does
Wisconsin.
he have a letter from Wisconsin saying he's in good standing with their auction board?
Yes.
He is in good standing with that board now. Is he licensed in other states? You said he does this all over the country?
He says that he does it all over the country. I don't believe that he provided any information about the.
We don't require them to list all the states in which they are licensed.
They listed on this application where their other licenses were.
He had to go back and take the test in Wisconsin. Mm-hmm.
Taking on a big task, but
Probably need to get something passed where we do background checks like other places do.
Oh, apparently it's not on the application. I thought it was, but I'm not locating it.
And he's had his Wisconsin license since '01.
No, I believe he's had it since '94.
Well, I mean, the reason I said that was in
Oh.
'01 they suspended him, and
Yes.
or in 2000 they did, and then he got him back in February of '01 if he'd done everything he's supposed to do.
Yes, his original license was issued 3/1 of '95. His original. I can certainly go back and ask for additional.
I would like to postpone the approval of this application, would be my recommendation, until you can discover what other states he is licensed, and to find out if he is in good standing with those states. I think that's pertinent to this application. Even though he does meet all the requirements, as counselor has said for our application, I think it's, I'd hate to approve an application and come to find out he's, had complaints in every other state and is under investigation by the state of New York or whatever. I wouldn't want to be that commission that did that. If we can discover that he's fine everywhere else, and I have no problem approving the application, but I just don't think we have enough information. If you could go back and ask him, and unfortunately it's going to be at least a 60-day delay for him, because we're probably not going to have a meeting in December, probably January before we have our next meeting, which will give you adequate time to get all the information on this applicant, unless the board feels the need or the necessity to go ahead and approve that application today.
I agree, and it wouldn't hurt to give Wisconsin a call.
Yeah, I would just make contact there and just find out what you can about it. There's just it doesn't pass the smell test at this point. We just need to figure out what it is.
Okay.
I'll make a motion to put off the approval.
Second.
It's been moved and seconded that we postpone approval until the next hearing of the Tennessee Auctioneer Commission. All in favor say aye. Aye.
Aye.
Okay. We have a continuing education seminar approval, which is under tab 5.
This is the Tennessee Auctioneer Association Winter CE Seminar.
I need to recuse myself from that.
Yeah, probably so. Tab 5.
I know many of you know we redesigned the form. They've filled out the new form. They've attached the agenda. They've provided bios and information about what they will be discussing.
This is a industry update by Bobby Colson and Bear Stevenson, and then bid calling with a purpose I think Ryan is involved, Justin's involved in that. Deal or No Deal by Jason Miller. Auctioneering accuracy for the auto auctions. And this is, we have to approve this education as being CE for us, is that what we're saying?
Yes, sir.
Okay. Well, given the skeptical of the presenter of Ronnie, would you like to make a motion to approve that as?
I'll make a motion to approve.
All right, it's been, Andy, I will need you to
Second.
second that. All in favor say aye. Aye. All right, it's been a motion approved.
Got listed right under me, kind of bothers me.
I know
a little.
Bear Stevenson
It kinda
bothers me.
a
Yeah, I know
little,
it.
but,
I know it.
You know,
Well,
And
do
the
your
rec-
best, Bobby, and make sure that they learn something when you,
Yeah, and the record will reflect that Commissioner Colson recused himself
yeah,
from this
Bobby,
vote.
yeah, he did. All right. Next item, tab 6, is a log review for the apprentice auctioneer.
Yes, sir. And this, I don't know, I believe that this was a, more something that Mr. Phillips brought up at the last meeting. I don't
Right.
know if you want to review it this meeting or if you want to put it off. This was simply he had asked, I believe along with Mr. Colson, to see what some of the logs look like that we receive from apprentices.
Right.
And this is just a sampling of some that we've seen in recent times.
I don't think we have the right to approve these logs as such. I think this was just something, like I said, Mr. Phillips had asked for, and
and I kind of want to look at it too.
Bobby
just
did
for
too, just to see,
information.
what it is.
Let's just
what the
look at
dates
this again.
are.
Let's just look at this again whenever
Yeah.
Howard's here.
We'll just,
Okay.
just bring
Just
it
bring
back.
it back in
Bring it
January?
back the
Because
next
it's not
meeting.
anything we need to act on. or
Right.
anything.
No, sir, it was nothing to act on. It was simply that this is the form that they complete. This is the information that they provide to us. And of course, I can email this.
Have
if
we
you'd
got
like
the,
to see it in the meantime. And if there's anything with the form, we are going through and reviewing the forms. So if anyone has any suggestions that this needs to be revised,
The
more than
deal
happy.
that shows how much of what you have to have, advertising, bid calling, workering, clerking.
Yes, it's 1,000 hours, or 1,000 points, excuse me, 1,000 points in total, and the points are actually listed in the rules.
Okay.
Right. And you have to have the right number of points for each activity in the auction industry. The form's not really, the form's good for as a log as such. It's not good from from an analytical standpoint. They're not required to put in the columns, what points go where. I think that would be a good way to amend that form, so you could literally total them up by category. But anyway, that would just be a suggestion.
There's no, it's just the 1,000 points in
Right.
total.
Right, I know.
So,
Well, it's supposed to be divided up into different categories, supposedly.
yes, the point system, each activity is
Right.
its own point value.
All right, our next item is an apprentice application from Cody Shelley from Duncan, Oklahoma, tab 7.
Yes, sir.
He says, hello, my name is Cody Shelley, and I am from Duncan, Oklahoma, and I'm in hopes of acquiring a Tennessee Auctioneers license. I am licensed in both Arkansas and Texas, and due to me living in Oklahoma where there are no licensing laws, I do not have the possibility to reciprocate. The reason for wanting to acquire my license is to be ready and prepared as I make attempts to expand my auction business and do not want to miss out on an opportunity that could arise in the years to come. I'll be under the direct guidance of Mike Jones and Jones Auction Company from Martin, Tennessee. While apprenticing in the state of Tennessee, if approved, I'm eager to hear the board's decision. Hope you'll allow me to join your state and become a licensed auctioneer in the state of Tennessee. So he's going to live in Oklahoma, but he wants to apprentice under Mike Jones of Jones Auction in Martin, Tennessee. That's what the application is.
Yes, sir. This was actually received on Friday.
What is our standing on that, Bobby? Are we allowing that? I don't know that we've ever have.
We had one not long ago that was, she would do it again. She was
That's right. She was doing it under Wendell. That's
in
right.
Kentucky.
Right.
Oh, that you've mixed and mingled two different ones. You've had
Oh, I
two
have.
recently. My apologies. The one Mr. Colson is referring to the young lady, I believe, lived in Tennessee, and her auctioneer was in Kentucky, just over the line.
Right.
But also conducted auctions in Tennessee.
Yeah, but she didn't live nowhere near close to the line. I mean, she lived like
Right.
in McMinnville or something. She wasn't nowhere near the Kentucky line,
Yes, sir.
I don't think.
And the
Yeah.
one Mr. Morris is referring to was Wendell Hanson had an apprentice who lived in Nebraska or Iowa.
Right.
Nebraska.
Right. Nebraska.
Okay, I know he had to test in Iowa, so, but that was the other instance recently.
Why would they want to do this?
Probably Oklahoma doesn't have an auctioneer commission.
A lot of states don't have.
Stay where he's at, but he wants to be able to come to Tennessee and do
Tennessee
auctions.
license, but he don't have no.
Well, Tennessee won't let you get an auction license direct unless it's a reciprocal license. And we don't, since Oklahoma doesn't have a license law, they cannot reciprocate with us. And so the only other avenue to get a license in Tennessee is to go through the apprentice program. And there's no way to apprentice if you don't have a Tennessee auctioneer to sponsor you. And so that's what he's doing. He's getting Mike Jones from Jones Auction to sponsor him as a.
Yeah, you're right. That one I was talking about Kentucky's nothing like it because the apprentice actually lived in Tennessee.
Right.
Would this be a non-resident apprentice? I guess.
Pretty much.
I mean, like a non-resident.
It's a hole in our law that we don't.
Yeah,
we don't have a way for those guys to get approved that are coming from a non-licensed state.
Happen a lot.
And
No,
it's
not
also
a
a
lot.
hole in our law that you don't have to live within so many miles of your sponsor.
Right.
Too.
That's true.
Like a real estate. does.
Right.
You know, you have to.
2 miles, what you got to do?
Is that what it is in real estate?
No, I said, is apprentice auctioneer not 52?
Maybe. Yeah, I don't think there is.
Not under the auction law. Under real estate law, there is. It's got to be 50 miles.
I'm
from
sorry.
So it doesn't matter that he has a license in Arkansas and Texas
Well,
because of where he lives.
That's it has to be the state in which you reside to reciprocate with us.
Yes, and I looked at that this morning because when I first read through it, I was like, oh wait, he has other licenses, but no, he lives in Oklahoma.
Right.
If he lived in Arkansas,
Yeah, in the past, we've had people that would get a post office box in a state that reciprocated with Tennessee, even though they actually lived in one that didn't have a license law, to try to skirt around that.
Can he do that now? No.
Do we have, again, I would go back and where he says he's licensed in Arkansas and Texas, do we have any letters of good standing from those two states?
no, he didn't provide those, I'm sure, because of the fact that he's going the apprentice route.
Right.
He is going the apprentice route. He's not looking to take
Right.
the auctioneer's
Right.
test.
Right.
I mean, with it-
filled
Do you
out
have it? And did you talk, or is anybody you had any conversation with Mike Jones of how he plans on apprenticing this guy?
No, this was received late on Friday, and I've actually been out of the office.
Okay.
But I certainly, I didn't want to not present
It's
it.
going to take them a while to get that logbook we're just looking at filled out.
I know, that's my point. I mean,
Looks
I
like
don't
me.
he'd have to come to Tennessee to do it.
Right.
But I can certainly make inquiry
I make
of
a
Mr.
motion.
Shelley.
Go ahead, Ronnie.
I make a motion to put it off till next hearing and let Kimberly check with Arkansas to maybe get a letter of good standing and talk with Mr. Jones how he anticipates doing what
Okay. Motion's been made. Is there a second?
Second.
Been seconded. Is there any further discussion? All in favor say aye.
Aye.
Motion passes. So we'll postpone those two. That's all under your administrative report?
Yes, sir, that was all that I had.
Okay, well, Chris, we're going to back up and get on to tab 2 on the legal report.
Thank you, Mr. Morris. And just, I try to ask, especially when I'm filling in, what the commission's pleasure is in terms of either reading the report outright or summarizing it or allowing the commission to
Julie always reads it outright, and we kind of follow along and kind of helps us.
Okay, I'm glad to do that. All right, so there are 3 items on today's legal report. The first 2 complaints are against the same unlicensed respondent, and they are as follows. Complaint number 2014-00-9881 was filed by a licensee against a respondent, and as I mentioned, it's the same company for both these complaints. The complainant states that a respondent conducted an auction on April 26, 2014 without proper licensure, and that unlicensed individuals conducted the auction despite the fact that advertising stated that a licensed auctioneer was going to conduct the auction. Then moving on to complaint number 2014-016-911. This was filed by 3 representatives of an estate who engaged the respondent services. The complainants state that they met with the respondent's representatives to discuss options for liquidating household goods related to the estate. An estate sale was discussed, but the complainants state that they were later told the respondent found a way to conduct an auction because a licensed auctioneer had agreed to conduct the auction for part of the agreed upon price. The complainants state that they signed a contract but never got a copy, and the auction was set for April 26, 2014. The complainants state that this was an illegal auction without a licensed auctioneer, that the licensed auctioneer was unable to make it due to an emergency situation, and 2 individuals associated with the respondent functioned as auctioneer, neither of whom were licensed as auctioneers. The complainants have other complaints alleging that the sale was not widely advertised, that items were broken, that items were removed from the property, that an inventory of broken and removed items was not provided, that they were charged an undisclosed buyer's premium, that there was low attendance, that items were not sold, that items were sold at low bids, that items sold were substituted without agreement, and that there were items missing. Also, complainants state that items not sold were transported to an auction house to be sold, and the complainants do not know the name of that auction house. The respondent submitted a response to both complaints signed by an individual listed as owner-operator of the respondent company and an individual licensed as contractor for the respondent, stating that they met with the second complainants and signed a contract for the estate to be liquidated by on-site auction. The respondent states that a licensed auctioneer gave verbal agreement to conduct the auction, but later the respondent was told the auctioneer's partner would be the auctioneer. On the day of the auction, the respondent states that it was discovered the auctioneer scheduled to call the auction suddenly passed away. The respondent states the individual who signed the response as contractor for the respondent conducted the auction based on the circumstances. The respondent states that items which were not sold were taken to another auction house for liquidation. The respondent also states that both the respondent and their contractor have not conducted an estate auction before without a licensed auctioneer and would not have done so had there not been an emergency. An investigation was requested to determine more information about the subject auction as well as to determine whether the respondent had conducted any other auctions without proper licensure. The investigator met with the respondent's owner and contractor for the respondent and obtained an affidavit. The affidavit states that the contractor conducted the auction based on the emergency conditions described in the respondent's response, and then auction items that belong to the respondent and the contractor, with the remaining items being taken to another auction house, which does appear to have a gallery license. The owner and contractor state in the affidavit that neither individual has conducted any other prior non-licensed auction. Further, the respondents state that the allegations the respondent has conducted an online auction which requires a license are false, because respondent states that all of respondent's sales are conducted by proxy bid, which requires no license so long as it is a virtual internet auction. A copy of the contract with the second complainants was obtained, as well as other documentation relating to the sale. Other documentation relating to the second auction referenced in the affidavit was also included. It appears that the respondent and another auction firm held the proxy bid internet and live auction where items were sold in-house and by internet. It appears that the respondent received part of the buyer's premium for the items sold in-house, and the auction firm received the remaining portion. The two also each received part of the buyer's premium for items sold online. The information states that the expenditures were divided equally and respondent did the work of putting the sale on proxy bid, and the auction firm allowed usage of the facility for the auction. It appears to legal counsel, that means Julie, that respondent's involvement in both auctions constitutes unlicensed auction activity. While fixed price or timed listings that allow bidding on a website but do not constitute a simulcast of a live auction are exempted from licensure requirements by TCA 62-19-103 subsection 9, it does not appear that the proxy bid in-house auction falls within these constraints even with the involvement of the licensed auction firm. The recommendation is to authorize a formal hearing with authorization to settle by consent order with a civil penalty of $1,000 for violations of TCA 62-19-102, Section A1, relative to unlicensed conduct. If Mr. Phillips were here, he would need to recuse himself from the consideration of and voting on this matter. And so I went ahead and added that into the recommendation section for the record. And at this time, I will take any questions that I might be able to answer on numbers 1 and 2, and then need a
62-19-102A1, is that unlicensed activity?
yes, sir, it is.
Looks like to me we had some advertising violations too. Could that be added to it? I mean, if they were advertising as a auction company and it wasn't, and they had an undisclosed buyer's premium that wasn't advertised.
Mr. Colson, let me discuss this with the paralegal. She might be able to give me some insight on that.
He's unlicensed, so he can't fall under any of the other.
Basically, most of the laws and rules apply to licensees, and this guy is not a licensee. The company is not a licensee, so we go with the unlicensed conduct section. Now, if yeah, so that's the reason for that.
On one of them, it's talking about an auctioneer got sick or died or something that was going to do the auction. Had he advertised it, and then these people went and did it, or?
Sounds like to me they went ahead and did the auction even though the guy died.
That's exactly what happened. From my reading of the situation, it looks like the respondent had either retained, whether by contract, verbal agreement, or some other way, to have this licensed auctioneer come and do the auction, but then this person dies of a heart attack, like literally the day of, I think. And so the respondents appear to have admitted that they went ahead and went forward, given the circumstances, and
Instead of canceling sale as they should have.
that's correct.
Was there any contracts or anything between these unlicensed people and the buyers? And the sellers?
Well, looking back at the summary, the complainant said that they signed a contract but never got a copy, but a copy of the contract was obtained during the investigation. So there was a contract, and I'm not exactly sure why at that point something wasn't discovered. That
Unlicensed person would have a contract anyway.
Exactly.
Yeah.
that's where I was going with that.
Right. Chair will entertain a motion. Unless there's further discussion.
I'm like Bobby. I think the advertising is violated too, but we can't do anything about that, right?
Yeah, they're not licensed companies, so they don't come under that portion of the law.
Well, if they were advertising themselves as a auction company
Yeah,
or
but
not, it looks like it would.
We have no jurisdiction over that.
That
The only
stinks.
jurisdiction we have is they were acting as unlicensed.
Okay, well, I move we go with legal's recommendation.
Moves to a second. Second. All in favor say aye.
Aye.
We would do more if we could.
Needed to.
I understand. All right. The final item on the report, item number 3, is quite a bit shorter.
Okay. Go ahead.
The
Never mind.
complaint number 2014-016-041. This complaint alleges that the complainant consigned personal property items with the respondent in January. The complainant alleges that within the first week, some items sold and the complainant was promptly paid. Complainant further states that the respondent moved cities and complainant's items were listed as last sale with respondent going out of business. Complainant states that phone calls were not returned and that complainant requested a check by email. Complainant also states that a representative of the respondent called the complainant and stated that the landlord had locked the respondent out of the building, stolen the respondent's computer and files. Complainant states that they have not heard from the respondent since then, and the respondent still owes complainant money. The respondent submitted no response to this complaint. Recommendation is for a $1,000 consent order for violations of 62-19-112 B4 and then Rule 0160-01-.24 B4 in the statute being failing to account for or remit within a reasonable time any money belonging to others coming into the licensee's possession, and so on and so forth.
Respondent hasn't replied.
Okay, according to our paralegal, she did speak with the respondent, and the respondent was supposed to have sent something in but did not. So I think the recommendation I would make is that the respondent did not submit a timely response to the complaint, because if they come in later and submit something, that's fine, but they're still late. And then also on the recommendation part, I'd suggest adding in the language, the authorized formal hearing, and then go on with the consent order as is.
I move that we authorize for a formal hearing with authorization to settle by consent order with a civil penalty of $1,000 for violation of TCA 62-19-112B4 and Rule 160-01-24.
It's been moved. Is there a second?
Second.
Second. Any discussion? All in favor say aye.
Aye.
Aye. Motion carries. That's it for that part of it. And I think that's pretty much our agenda, unless anybody, now, have we, I want to bring up, we've decided we're not going to have a December meeting, right, guys? And do we have our list for 2015 in our folder?
I don't believe it's in your folder at this time.
Oh, here it is,
I-
meeting calendar, here it is.
But I believe it's 14. I don't believe it's the 15th. I can resend.
It's, our meeting calendar's right here.
But is it? Oh, was it in there? Okay.
Yeah, so there's no meeting in January.
Yeah, there is.
Well, it says here not, well, that says 13. Where did that come from?
That's what I'm saying. I don't believe
I got one
what's
that
in.
says 15.
I don't believe what's in there.
I don't have
No,
one.
you can't have mine.
Please, please. So January the 5th would be our next meeting. On Monday, January 5th, okay. And then we got February, March, April, May, June, August, October, November, December. Okay,
And as always, we'll evaluate each meeting if there's
Right.
no business.
okay.
Certainly.
So we are, I think we are adjourned until Monday, January the 5th.
I would like to say, I would like to
Excuse me.
And I don't know if this is something that I need to get, well, I'd like to get the other commissioners' opinion on it, and it seemed like we might have talked about this once before with Julie, but I don't remember. I think that we, and the way I understand, I may be all wrong on how we need to do it, and they might not even think we need to do it, and we're going with something else. But I think we need to require errors and omissions insurance for auctioneers, just like the Real Estate Commission requires E&O insurance for real estate licensees. It's my understanding, and I would like someone, with the board's blessing, you, Julie, whoever, to check on what we would need to do that. Seems like somebody told me one time it would take a statute change, and then we'd have to give everybody a couple years to comply, a couple of licensing periods or something to comply, and
You'll have the recovery fund.
yes, it had the recovery funds for the general public.
Yeah.
Right.
This is for the auctioneers.
I got
Just
you.
like this guy that was up here a while ago. If he had had E&O insurance, E&O would have paid for a lawyer for him to have been up here today. See what I mean? And, yes.
If you would like me to, I'll just give a general overview because I have not read your statutes yet. but-
Tony,
Oh,
use the mic.
Microphone.
I'm sorry.
We're the ones who say, please speak in the microphone.
Thank you, sir.
I haven't read your statutes yet, but generally, something like an E&O insurance, unless you have this very broad section in your statute already, would probably be a statutory change.
Yeah, I think it would.
Usually that happens two ways. There's one way that it can happen within the department, and that's through the legislative package that goes up to the governor's office every year. And so what we do is before the summer, every year we send out an email to all of the boards that if there is some legislation that you would like to go to the legislature through the governor's office, present that to us. And what happens is that goes through. That information is given from the boards with their attorney, and it usually has to do with the board members that want these types of legislations that go through. And what the process that happens is it goes through Bill Giannini's office, and then it goes to the commissioner's office, and then it goes to the governor's council. So there's several levels of review we do.
I'm sure.
So if it gets filtered out so that there's, we start with maybe, 50 and then we get down to 5, and it all depends on the political atmosphere and how that relates to the department and how it helps with consumer protection and whatnot. So that's one path that we do every year. And then the second one is where you would go through the General Assembly yourself. And generally the way that that's done is that the board members would get with their industry group representatives, with their lobbyists, and they would push it that way. So that's completely aside from the department where we do that. So the official way that we do it is through the yearly package to the governor's office. And then the way that board members can do that is to get with their industry representatives through those lobbyists. What we don't do generally is just go forward and meet with the legislature.
I
ourselves.
knew it had to be.
We
a
call
process.
that bootstrapping, right?
Right.
Yeah, we call it
I knew it had to be
bootstrapping
a
and
process.
right.
Yeah.
So those are probably the two ways that are done. So at the end of the year, we can definitely look at putting that into the package, and that would be approximately next May that we start that process, because we're just now finishing the ones from last May that we would send them up to go into this
So
section.
we would be looking at the next year before
Yes.
it got,
Yes,
okay.
sir. Yes, sir.
Well, I mean,
That's
if I
how it
don't
is.
bring it up now, then it's gonna be this time next year, and I'm gonna be saying then it'll be another
That's
year.
true.
You know.
That's true. And then always you could go through your
Right.
industry members.
Well, it wouldn't hurt to start if, like I said, I don't even know what you guys think about it, Jeff.
I think it's a definite plus. It's another $250 a year, but it also saves, again, where these guys could have, bring up a complaint up against and have legal counsel represent them. I think it'd be very helpful. It just, I have it anyway.
I've got insurance out
Oh, I know.
and I've got one right now with personal property that none of it covered.
Right.
And I thought it did, so I'm speaking from personal experience.
I'm not sure what the premiums would be on it, and that would be the other thing is if
Yeah,
you could get something with Rice or some of these big E&O companies that could do it on a bulk basis where it would be cheap enough for them to do it. If it costs thousands of dollars, it'd probably not be.
It seemed like before when I talked to someone about it, I don't even remember who it was. They said if once you ever got it passed and all that, like you were talking about, then the state would have to put it out for bids to people like Rice and
Right.
stuff like that. But I'm sure, you could get a pretty good deal on it.
Right. Yes. Because the way we do that with the real estate commission, how their E&O is set up is that obviously if people do not purchase E&O insurance and they're at a lapse, then the program purchases it almost basically on behalf of that person, so that there is some coverage, and that's negotiated.
And what made
through
me
the
think
state.
about it, I guess it was one day last week I came in, my little deal from Rice was there, so I mean,
Right.
it's due this year, you know, it's every licensing period, I guess.
Right.
Or every 2 years, I think it's every 2 years. But anyway, that's all I had, just something to think about. Thank you.
Make a motion to adjourn.
Second.
All approved, say aye. Or get up.
Get up.
Thank you, guys. It was,
What did Julie name her baby?
Parker.
Parker Allen. That's a good name.
I got a son